Okay, thank you everyone for joining us here today to discuss the state of the civil justice environment here in Pennsylvania and how trucking is affected by lawsuit abuses that result. This is a part of what we hope to be a monthly webinar series. Last month we had a great webinar on cybersecurity, which we have that video available for anyone who missed it. And next month we're looking at additional monthly webinars. But for today, we are very fortunate to be able to introduce you to Curt Schroder, who is the Executive Director of the Pennsylvania Coalition for Civil Justice Reform, or PCCJR, which is an organization devoted entirely to legal reform in Pennsylvania. Curt will be joined in our discussion today by PMTA member Doug Marcello, a trucking defense expert who knows firsthand how an abusive legal environment affects trucking companies. A few housekeeping items. First, we do have time built in for questions, so please type any question that you may have as we go along, or any requests for additional information into the chat box, and we will ask them of our speakers here when we get to Q&A. With that, I would like to introduce Curt Schroder. Curt is a Philadelphia area attorney who serves as Executive Director of the Pennsylvania Coalition for Civil Justice Reform. I'd like to note that PMTA became a member of PCCJR this year because we believe the work that they do to limit lawsuit abuse in Pennsylvania is really important to the trucking industry. And we thought it was important to join the PCCJR team. So we're excited about that. Curt served as a member of the PA House of Representatives for 17 years, representing people of Chester County. He spent his time in the House working to restore fairness to Pennsylvania courts, including work on medical malpractice reform, where he helped stem the flow of doctors that were leaving the state for liability reasons, and the Fair Share Act, which I think he's going to plan to talk about here today. I'd also like to introduce Doug Marcello of Marcello and Cavisto and Blue Wire. Doug is an attorney with a CDL who defends trucking companies here in central Pennsylvania and throughout the country. He has spent more than 30 years in litigation, and I'd venture to say he's probably seen it all. He does everything from immediately respond to one of his clients' accidents to following a case all the way through jury trial. His new venture, Blue Wire, employs data analytics in defense of the trucking industry, monitoring vulnerabilities, recommending corrections, and defending the reputation of trucking companies. Thank you both for taking the time to be with us today and to talk about this important issue. I'm going to turn it over now to Curt for his presentation and then ask Doug to lead a discussion from there. Thanks, gentlemen.
Thank you, Rebecca. And Rebecca and Doug, it's good to be with you, and thank you for asking me to participate in this webinar. And good afternoon to those of you who could join us. What I thought I would do for a few minutes today is tell you a little bit about the Pennsylvania Coalition for Civil Justice Reform, who we are, what we're doing, why we came into existence, talk a little bit about the litigation, the business and litigation climates in Pennsylvania, and how one impacts the other. Then I also want to talk about a couple specific issues in Pennsylvania that the trucking industry and really all businesses in general should be aware of and should be concerned about. For far too long in Pennsylvania, those who bring lawsuits for a living, the plaintiffs' bar, the plaintiffs' attorneys, and their related organizations, for far too long, they had their way with the General Assembly. And since 2015, they have had their way with the courts too, particularly the Pennsylvania Supreme Court. And PCCJR was established to change this and to chart a new course and a new direction in Pennsylvania. And we're about fairness, fair laws and fair courts. The Pennsylvania, let me tell you a little bit about the organization itself. We're a membership-based organization. We have a 15-member board of directors comprised of both business and healthcare and other professional interests. we have different committee, different membership levels, including the steering committee, corporate committee, small business members, nonprofit members, and individual memberships as well. And I'll talk about this a little later in the presentation, but I think I mentioned we have 15 board members and we have about 30 additional members at the various levels of membership in the organization. And in my view, the Pennsylvania Motor Trucking Association, we were very pleased to have you come on board, because I think you bring an entirely new element of membership to PCCJR that was missing, a very important element. First of all, from what I understand, all the various family-owned trucking organizations, trucking companies that are part of your organization, you bring a unique grassroots approach, a unique grassroots capability now to PCCJR that, I think benefits us greatly. And we want to make sure that we work to benefit the Pennsylvania Motor Trucking Association and all of your individual members, during our relationship as well. So the big question, why a Pennsylvania Coalition for Civil Justice Reform? Why and how did we come about? We know the last major piece of court-related, civil justice-related legislation that went to a governor in Pennsylvania was back in 2011 with the Fair Share Act. Now, the Fair Share Act replaced what you might have once heard as a joint and several liability. So prior to the Fair Share Act, if say one of your trucks was, one of your members was involved in an accident, perhaps a multi-defendant accident, and you were sued under plain, simple joint and several liability, even if you were only say 20 to 30% at fault for that accident and for the injuries that were incurred in that accident, you could still be required to pay 100% of the verdict. And that is, that led to a lot of extra defendants being sued in these civil cases, regardless of really whether they had much or any liability at all, but they were sued merely because they were seen to be a deep pocket and someone, from whom the plaintiff could collect damages on. After the Fair Share Act was implemented, and this was back in 2011, I was still a member of the House during the time and took a very active involvement in shepherding this bill through on the floor of the House when it came up for a vote. But after this was signed into law by then Governor Corbett, now if you are sued in a personal injury case, you only have to pay the percentage of the verdict for which the jury assigns you liability or fault. So same situation, if you're 20 or 30% at fault under the Fair Share Act, well, you can be certain that you will only pay 20 to 30% of the verdict or of the judgment in a case. So it just promoted fairness. I think we would all believe and all say that it's unfair to have to pay 100% of a verdict if you're only incrementally at fault. And if you only have a small assignment from the jury of liability and percentage of fault, well, then you should only have to pay that amount, that percentage of the overall verdict. So that's the Fair Share Act and why it was enacted. And it's done a great job in altering the civil justice landscape somewhat in Pennsylvania. But after the Fair Share Act was successfully enacted, a coalition had been brought together and had come together to push that piece of legislation. It was a broad-based coalition comprised of business and healthcare related entities and interests. But after it was passed, all the coalition members, then retreated back to their individual corners. Okay. The effort was over. And so the coalition that pushed this through broke up, because after all, whether you're a business organization, say like the Pennsylvania Chamber, or you're a medical organization like the Hospital Association or the Truckers Association, Pennsylvania Motor Trucking Association, at any given time, you have a host of issues, a host of public policy issues that are before you and that you are concerned about in the legislature. You're tracking these issues. Rebecca and others are doing advocacy on these issues. And both individual companies as well as trade associations and statewide organizations did not have the time or the bandwidth to devote all their time to particular civil justice issues. However, there's one organization that did not go by the wayside and did not, in essence, retreat back after that was passed. And that organization was our friends at what was then called the Trial Lawyers Association, and has since changed their name to the Pennsylvania Association for Justice. No, they took it on the chin with the Fair Share Act. They weren't pleased. They didn't like it and still don't like it, but they didn't go anywhere. They continued their major presence in the halls of the Capitol. They continued lobbying legislators, and basically made sure that their interests in expanding liability, expanding exposure to liability, increasing damages, increasing the jurisdictional reach of Pennsylvania, and all the other issues they work on, they just kept going. So there was no answer after the Fair Share Act to the work of the Pennsylvania Trial Lawyers Association, or as they're called today, the Pennsylvania Association for Justice. So that's why Pennsylvania Coalition for Civil Justice Reform came into being. It was realized by those who had concerns about civil justice issues in this Commonwealth that a standalone organization was needed. It was needed to counter the activities of the Pennsylvania Trial Bar, and was needed to stand up and advocate and be a voice for civil justice fairness, and to, in essence, rebalance the equation in Pennsylvania. Now, since PCCJR has come into being, as I said, prior to this, the last act to go to a governor for his or her signature was the Fair Share Act in 2011. Well, since we've come into being, we have sent two bills, two major pieces of legislation to the governor, to Governor Wolf, for his consideration. The first bill was a bill to end certain abuses in workers' compensation. You might recall there was a controversy where these pharmacies that were owned by law firms in Pennsylvania, that law firms that primarily did workers' compensation work on behalf of claimants, they were doing this compounding work and concocting compounded pain cream that they would then sell and charge to workers' compensation through these attorney-owned pharmacies, and the doctors that were sort of in that network that the workers' comp claimant attorneys sent their injured clients to see them. They would charge outrageous prices for these compounded pain creams. They would use simple products like lidocaine and some others, compound them together, and off the shelf you could buy those ingredients for $100 or usually much less, but they would be charging thousands of dollars for these pain creams. So we promoted a bill to end that practice and would have established a prescription drug formulary in Pennsylvania for workers' compensation that would have, through the means of operations of that, prevented this type of thing from happening. Well, it went to the governor's desk. We were successful in getting it past the legislature. It would have benefited all employers in Pennsylvania with their workers' comp costs, and stop this abusive practice from occurring in the workers' comp system. Governor Wolf saw it differently and vetoed that bill. The next bill that we passed was at the near the end of 2020, during the height of the COVID liability, the COVID-19 crisis. We passed House Bill 1737 to provide COVID liability protection for all businesses in Pennsylvania and all healthcare providers in Pennsylvania. Well, you might have guessed it. Once again, that bill met up with the governor's veto pen. So while we have not been able to break through sort of the brick wall that the governor has put up on these issues, we have had success in getting these major pieces of legislation through the General Assembly. And we have our fingers crossed, and we're quite hopeful that next year will bring us a new governor. That much is known, that much is certain. Hopefully it brings us a governor who will look favorably upon our issues and will work with us to enact needed legislative changes regarding civil justice in Pennsylvania. So let's talk a little bit about the lawsuit climate in Pennsylvania. The U.S. Chamber in Washington, D.C. has performed a number of studies over the years on the cost of court systems and the cost of civil litigation and its impact on businesses. And in their most recent study, they've determined that Pennsylvania has the 5th most expensive civil court system in the country. It's estimated that it costs Pennsylvania $18.4 billion. Lawsuit costs attributed to medical malpractice alone in Pennsylvania is $1 billion. And an entire 2.5% of Pennsylvania's gross domestic product is eaten up by lawsuits. So lawsuits are expensive. Let me see. Okay, can't move that. Lawsuits are expensive. Total costs and compensation of lawsuits, I believe that says in 2016 was $18.4 billion. And this translates to over $3,721 a year spent on lawsuits per household in Pennsylvania. Now, if Pennsylvanians paid that expense directly, it would be almost double what the average household paid for gas that year. Maybe not what the average household is paying for gas at the moment, but that's a different story. Gas prices weren't quite as high back then. And also more than what the average household paid to dine out during that year as well. And I think it's also important to note that lawsuits are can be a very inefficient way of handling and settling disputes. In Pennsylvania, only 56% of that $18.4 billion figure that I mentioned actually went to the plaintiff to compensate, the plaintiff for their alleged injuries. The remaining 44% went towards lawyers' fees and other expenses and other court-related expenses. So every day, Pennsylvanians are harmed by frivolous lawsuit and what we term as lawsuit abuse, be they small businesses, the medical community, and the people who work for them are particularly vulnerable to the impact of lawsuits and lawsuit abuse. Now, there's an organization that you might be familiar with called the American Tort Reform Association, or ATRA. And each year, ATRA studies the trend of civil cases in each state You know, particularly as they rise through the appellate courts of each state up to the state Supreme Court. And they create an annual judicial hellhole list as a way of, you know, pinging these court systems in each state, and, you know, making known some of the abuses and some of the bad public policy that emanates, you know, in these particular states. Well, both the Philadelphia Court of Common Pleas and the Pennsylvania Supreme Court for the past few years has been very high on the judicial hellhole list ranking. Prior to 2021, in 2020, Philadelphia and the Supreme Court were determined by ATRA to be the #1 judicial hellhole in the Commonwealth of Pennsylvania. Now we slid down to #4 this year, which is still nothing to be proud of. And interestingly enough, some of the legal journals, particularly in Philadelphia, kind of hailed that as some accomplishment and as you know, indication that, hey, improvements, you know, were being made, right? Well, if you read the Judicial Hellholes report for 2021 that came out in December, and I'm sure they didn't, okay, but if you read it, you know, clearly states in there that this does not represent an improvement on the part of Pennsylvania at all. It's just that several other states deteriorated in their judicial climates, you know, over 2021 that they eclipsed us. So it's not that we got any, it's not that we, you know, bettered ourselves. It's that other states, you know, became even worse. Yet, as I said, there were some who hailed that as a sign of improvement in Pennsylvania. And obviously, you know, when your state gets a reputation as a judicial hellhole or as a bad place to do business because of the litigation climate, you know, it's going to impact, you know, a business's willingness to locate here. It might impact your willingness to expand your business in Pennsylvania, and certainly, you know, will cause other states to be looked at more favorably than Pennsylvania in that regard. I've mentioned, you know, our work in the legislature. Something else that we do is file amicus briefs. Now, amicus briefs are also commonly called friends of the court briefs. And a friend of the court brief is filed not by a party in a litigation, but it's filed by an interested organization such as ours, such as PCCJR, that is concerned about the possible outcome of a court's ruling, and mostly the Pennsylvania Supreme Court. That's where most of our amicus brief action takes place. So if we are particularly concerned that a case is going up on appeal to the Supreme Court and the court has agreed to hear it, quite often we will file an amicus brief to advise the court, particularly on the public policy implications of what their decision might be. You know, we can warn the court that if they go a certain route or make a certain decision, what the impact will be, the negative impact on the Commonwealth of Pennsylvania, on businesses and on healthcare. So we have become not only the voice in the legislature in Pennsylvania, but also a voice in the court system. Once again, prior to PCCJR's existence, the Trial Lawyers Association for Justice would constantly file amicus briefs, and quite often the Supreme Court justices would only be hearing their point of view as to, you know, how they, you know, believe the Supreme Court should rule in a particular case. You know, now we're there to present, to be your voice and to present, you know, your point of view in these cases as well. And just as one example, well, what type of cases are you talking about, you might ask? We are about to file an amicus brief in a punitive damages case that the Supreme Court has just agreed to hear. And in this case, there was a punitive damage award which was 9 times greater than the compensatory damage award. Now, what do I mean by punitives and compensatory? Compensatory is what the plaintiff is awarded for economic loss, for pain and suffering, and those type of damages that are designed to make the injured plaintiff whole. Okay, punitive damages, on the other hand, they're not there to award the plaintiff, although they end up doing that in the long run and end up giving the plaintiff's attorney a greater fee to take home, but they're there to punish bad activity more than anything. Okay, in other words, it's a punitive damage. It's a punishment to the defendant for what the court feels might be egregious activity that led to this particular injury. So the U.S. Supreme Court has strongly suggested or ruled that punitive damages, which are in the amount of 9 times the total amount of compensatory damages, might very well be unconstitutional. I'm not sure, don't hold me to that 9 times figure. 9 times is the issue in this particular case. I actually think the court has determined something lower than 9 times. But nonetheless, this is being brought up to the Pennsylvania Supreme Court, and they'll be citing U.S. Supreme Court cases in favor of our proposition that 9 times compensatory damages is just unconstitutional. It's too great a punishment. It is out of whack, if you will, and doesn't fit in with the amount of compensatory damages, or is not reasonably related to that. So that's an example, just to give you one, of a case that we will be diving into very shortly, as the Supreme Court has agreed to hear that. So I wanted to talk to you also about a couple issues in Pennsylvania that they're very much before the General Assembly and the courts at this moment, and they're issues that you should be concerned about. We already mentioned the Fair Share Act earlier. I want to go into a couple cases that have eroded the Fair Share Act and have vitiated the legislative intent in enacting the Fair Share Act. And I also want to discuss the medical liability venue rule. Now, you might say to yourself, well, hey, we're not doctors, we're not hospitals. Well, why do we care about this medical rule, whatever venue is? Why do we care about that? Well, bear with me. I'm going to try to explain to you why you should care and try to make you care. So let's take a look at the Fair Share Act first. You'll recall that the Fair Share Act was enacted in 2011 and ensures that if you're a defendant in a lawsuit, you're only going to pay the percentage of damages that was assigned to you by the jury in the court case. Well, there's a couple cases that have significantly eroded the Fair Share Act. One was Roverano versus Crane. Now, it's a rather narrow case in its application, but it held that the Fair Share Act does not apply in strict liability asbestos cases, and the damages must be apportioned on a per capita basis as opposed to a percentage of fault. So, in other words, if there were 5 defendants in this asbestos case, you would divide the damages 5 equal ways, regardless of fault. Now, keep in mind that the Fair Share Act has a provision plainly stating therein that this act applies to strict liability cases. Okay, it could, believe me, it could not be any clearer, it could not be any plainer. Yet our Supreme Court, in another example of why ATRA has dinged them as a judicial hellhole, our Supreme Court has held that the Fair Share Act does not apply in asbestos strict liability cases. There's another case, however, which is of greater concern, I think, to businesses in general, and that's the Spencer versus Johnson holding, where a panel of the Pennsylvania Superior Court determined that the Fair Share Act does not apply when the plaintiff is negligence free. In other words, only if the plaintiff has some level of contributory negligence does the Fair Share Act apply under this decision in the Superior Court. That's problematic for a lot of reasons. It represents just another severe misreading of the act and what the intent of the General Assembly was in passing the act. There was never a distinction made in the act between plaintiffs that are partly responsible for their own injury versus those plaintiffs that have no responsibility for their own injury. Yet this court has interjected that. So, let's say that one of your vehicles, is involved in an auto accident, and perhaps there's two vehicles partly responsible for the auto accident. And let's say the plaintiff did nothing wrong. The plaintiff was stopped at the red light, the plaintiff was stopped at the stop sign, whatever the case might be. But your vehicle and another vehicle converged together to actually cause this accident and render harm to the plaintiff, who was without liability at all. Well, under this reading of the Fair Share Act, your truck driver and your vehicle might only be, say, 20% at fault. But if the plaintiff has no negligence, his or herself, you can still be tapped for the entire amount of damages to that plaintiff.
I can throw something in here, Curt.
Yes.
Hey, Curt, this is Doug.
Yeah, Doug.
And I just, other than just being eye candy here, let me just jump in for a second.
Sure,
But,
please do.
One of the things, and you're absolutely correct on this, and let me even bring it home even more. We consider that 90 to 95% of all suits settle, don't get the verdict. So what this does is give the plaintiffs leverage on these matters.
Absolutely.
And basically say, hey, there's a case out there that says, so to take your example, and let me take it more extreme. Let's say a car rear ends another car, pushes them into your truck, and you have virtually no fault. In fact, FMCSA would probably take it off your CSA score. But the plaintiff says, if there is something that we find or the jury finds you 1% at fault, you shouldn't have been stopped at that time or something like that, you can end up paying the entire verdict, particularly in a situation where the car probably at most has $15,000 in limits.
Right.
Or in many of the jurisdictions, or some of the jurisdictions, or one of the jurisdictions in Pennsylvania has no insurance. So it is monumental, and to take the Fair Share Act and somehow to twist it around this way, it's just is incredibly impactful and unfortunate in the circumstance.
Doug, you're absolutely right. I tend to talk, in context of the actual court actions, themselves. But you're right. Most cases settle. Most cases never make it to court. And they're now going to be settling for higher amounts. And there's going to be a greater likelihood of forcing you to settle also for a higher amount than before, than before the Spencer versus Johnson case was decided. So, and just to, bring it home, both the Ravarano and the Spencer decisions represent a pattern of erosion by the appellate courts in Pennsylvania of the Fair Share Act, which is only going to continue. Okay, it's only going to continue. The plaintiff's bar has this act set in their sights. They know they can't overturn it in the legislature. So they're going to bring select cases, and they believe they have a favorable Supreme Court and some favorable appellate courts. that they will be able to not do away with it, but injure it to their benefit. Okay. So that's what we see here, and it will continue. It's only a matter of time before the next case, comes up on appeal dealing with the Fair Share Act, that they will raise some other issue and have under this court pretty decent chance of being successful. So let's move on to medical venue and medical liability. First of all, what is venue? Well, venue is the question of where you can bring a case in Pennsylvania. And if you're a plaintiff's attorney, and if you have any possibility of bringing that case in the city of Philadelphia, you are going to do it. Doesn't matter if the accident occurred out in, Westmoreland County, up in the Poconos. I mean, pick your place in Pennsylvania. If there is some tangential connection to the city of Philadelphia through, ownership or, corporate ownership, or maybe, doing business there, or whatever the case might be, you better believe they're going to bring that case in the city of Philadelphia. And why is that? Well, it goes back to why Philadelphia, was labeled a judicial hellhole by the American Tort Reform Association. Philadelphia is known for its, nuclear verdicts. It has the highest level of $1 million verdicts, $1 million plus verdicts every year in the Commonwealth. And litigation in Philadelphia is a jackpot mentality. I compare it to a circus, wheel spin. I forget what they're called, but you spin the wheel and see what you win. That's pretty much the way it goes in Philadelphia, unfortunately. Now, what's happened with medical liability cases is that back during the height of the medical liability crisis in the early 2000s, a very beneficial rule was enacted that says in medical malpractice cases, you can only bring a suit in the county in which the injury actually occurred. Actually, it says in which the cause of action occurred, but that means where the injury occurred. So, if a plaintiff, if a person is operated on in a hospital in York County, for example, that case would have to be, and there's an injury, that case would have to be filed in York County. Okay, not brought into Philadelphia because maybe the attorney in the practice also has an office in Philadelphia. Okay, this cut down on the amount of medical negligence cases brought in the city of Philadelphia drastically. It really had a great impact. And it was a leading factor in stabilizing medical liability insurance costs in Pennsylvania after this rule was enacted. Now, this rule was enacted by the court. It is a rule of civil procedure. And it has been working well, for 20 years. As you might guess, there's one group of people out there who do not like this rule, hate this rule, and have hated it from its inception, and that is our aforementioned friends in the trial bar, the Pennsylvania Association for Justice. They have prevailed upon the court and a committee of the court called the Rules Committee to re-examine this rule. And they have proposed that it be done away with, and that we go back to the old venue rule prior to 2003, which allowed all this venue shopping to take place and have all of these liability cases, medical liability cases, brought in the city of Philadelphia. We've been fighting this now for 3 years. There are some indications that we might have to change our strategy a bit. I'm not prepared to make any announcements as to what that's going to be, but we tend to believe that our current strategy has run its course and that the committee either has or will recommend to the court that they do away with the current medical liability venue rule. Now, with all that said, you're probably still thinking, okay, that's a shame, but why should we as the trucking industry be worried about this? Well, there's several reasons. One is it will have an impact on your healthcare costs. If all of these medical negligence cases start being brought in Philadelphia again, or Allegheny County, or some other areas, it's not just Philadelphia, to be clear. But if all these cases are brought in these urban environments, which tend towards a jackpot litigation mentality, the cost of healthcare is going to rise again. There's just no way around it. Medical liability costs will go up for your doctors and your hospitals, and that will be reflected in the cost of healthcare. The other reason, though, why you should be concerned is a little more direct, I think. For years, the business industry in general has said they would like to have the same venue protection that the medical community has. In other words, businesses in this state would like to limit venue so that they can only be sued, in a place that's relevant to the actual lawsuit, not dragged clean across the state to Philadelphia, as many are right now. So if the point is, if the Supreme Court does away with this rule, it is going to put venue reform for the general business community just that much farther out of reach. Okay. So we have been fighting this. There may very well soon be a reason for the business community, Pennsylvania Motor Trucking Association, and others to get directly involved. We are contemplating whether to move forward with a constitutional amendment that would allow the General Assembly to legislate in this area. Right now, it's the sole province of the courts under the Pennsylvania Constitution. The only way if the courts do this damage that we fear they will, the Supreme Court, the only way to correct that would be to give the legislature authority to correct it in the state constitution. So a constitutional amendment is under consideration. We are meeting, our board is meeting on that issue again tomorrow to decide about moving forward with that.
And that, Kurt, would be invaluable to the trucking industry.
Yeah.
Because, with the current standard the way it is, if you make deliveries in Philadelphia of any significance, and significance is going to be defined by the court who's going to decide that, which is,
that's right.
You've heard it talk about the Philadelphia courts before. That means that these actions can be brought in Philadelphia. I can't tell you the number of cases I've had, central and western Pennsylvania accidents, and that that have resulted in that. A contract action between a Pittsburgh company and a Detroit or a Michigan contractor ended up in the Court of Common Pleas of Philadelphia. Now I can't complain too much because I won that. So we'll forgive him on that one, Kurt. But now the other thing is,
hey Doug, if you can win in the city of Philadelphia, I'm hiring you next time I need someone. That's all I'm saying.
Thank you. But the incredible thing, Kurt, is our rules in Pennsylvania for venue are worse than what the Supreme Court has set for the United States.
Yeah.
Supreme Court says, in federal cases, it's either got to be where the cause of action occurred, where the accident happened, or where I believe it's the home office or principal place of business of the company is. Where in Pennsylvania, you can be looped in if you are in the Commonwealth and brought into Philadelphia on that.
Yeah.
So yeah, I
absolutely.
think venue reform is crucial to the trucking industry in this regard.
It is. So I think, because of the impact on healthcare, which the trucking industry and all businesses, are always concerned about rising healthcare costs, but also for any possibility of getting general venue reform for businesses. Absolutely. Okay, just a couple final things here before we go into whatever discussion you might want to have. Each year, PCCJR puts out a voter guide. You might not know, but every year is an election year. Some people think it's just every 4 years. Some maybe every 2 years, but really every year is an election year. And this is just the cover of our 2018 voter guide, which was the last voter guide in which we had a gubernatorial election. Of course, we have a gubernatorial election coming up here in 2022 in the May primary, which I believe is May 17th. There are a slew of candidates running in the primary. There's one Democratic candidate running on the Democratic side, so that person will be their nominee. On the Republican side, there are 9 candidates running, which is quite unusual. That is a field of candidates unlike anything that we have seen, certainly in recent history in Pennsylvania. So probably later next week, PCCJR will be publishing its 2022 voters guide. And in that guide, we'll have the responses to the candidate questionnaires that we have sent out to the gubernatorial candidates, those that answer it and submit them. So we have asked the candidates a number of questions. Fair Share Act is one of our questions. Venue is another question, including whether they believe that business should have the same venue protections as the healthcare industry, by the way. Along with a couple other relevant questions. So we will certainly notify our members when this is published. And you will be able to access it on our website, or maybe Rebecca will make it known to the organization to offer members that this is available. And we would encourage you to take a look to see where the candidates stand on these issues. Usually we do not publish it until the general election, but because of the sheer volume of candidates running in this primary, we thought we would move it up this year and allow voters to see how the primary candidates stand on important civil justice issues. Once again, we're a membership-based organization. We have 15 board members. We are at our full complement, but we have plenty of room available on steering committee, corporate membership, small business, nonprofit, and individual. I must say, our small business membership, I think, is a very reasonable, yearly dues ask. If anyone, after this is interested, I would be happy to send additional information on our membership levels, including the dues requirement for each level. We would hope that you would consider direct membership in PCCJR. Many companies who might be represented in PCCJR by their statewide association, many companies decide also to become direct members of PCCJR, and we hope that you all consider that as well. Finally, PCCJR can be found on Facebook and Twitter, and I might also mention we are now on LinkedIn as well. And this is how you can contact us. I can be reached at Curt@pccjr.org, and our website is PA4civiljusticereform.org. So Rebecca and Doug, with that, I really appreciate the opportunity to make this presentation. I would be happy to answer any questions that you or anyone in the audience might have.
Thank you,
Great
Curt.
information, Curt.
That was a
Thank you. Go ahead, Rebecca.
Yep, I just wanted to say thank you and offer that if anyone has any questions, you can raise your hand or type them in the chat box. That was a great overview of PCCJR and why what you're doing is really important to the trucking industry. Go ahead, Doug.
No, I was just going to say, let me second that emotion. Great presentation, Kurt. Exceptional information. And it also drives home why it's so important to get involved in these elections. And there are no inconsequential elections. All
Well, that's
elections
true.
matter, you know, and we see these things on the ballot in terms of particularly for, people have seen the impact that the Superior and Supreme Court can have on their own personal companies. And that's
Right.
why it's necessary to study these issues and go into it. You know, you and I were talking last week. There is this decision out of the Superior Court that the plaintiff in a case can present to the jury the entire amount of the lump sum workers' compensation settlement. Well, that has nothing to do with damages. That's what the
Right.
insurance company is paying the person to get rid of them because they can't get video of them chopping down a tree. I mean, that's what that is, you know. But you know,
Yeah.
it's like, well, put it there in front of the jury and do that. It's totally contrary to so many concepts of Pennsylvania jurisdiction and jurisprudence. So incredibly crucial. Rebecca, did I see a question come in?
We do have a question. And the question is about technology that some trucking companies are using now. What effect does video camera on board the vehicle to assist in visibility? What effect does that have on the facts of a collision?
Maybe, Kurt, if you don't mind, you know, my standard line is like 15, 20 years ago when this first came into operation. My initial reaction was, you know, it's just one more piece of evidence. I'm going to need a proctologist to get back. But here's the deal. We get blamed for everything anyhow. Anecdotally, I hear from companies that 80% of the accidents, the camera absolves them. So with the camera, we have proof to overcome that reaction of it's the, you know, it's like the headlines in the paper, truck accident. Well, there are cars in there. The camera is invaluable in terms of being able to capture, document, and provide that information. I've had it with everything from tickets to roadside inspections to all kind of things. So the cameras are invaluable in the whole process.
80%, Doug, is that what you said?
Anecdotally.
Okay.
And if people say it, it must be true.
That's
So,
amazing.
but that's just, you know, historically where I'm sitting, there is a company over here that 2 a.m. had just finished installing a camera in their truck. It went a quarter of a mile and it was hit by somebody who ran a red light. 2 days later, that insurance company for the four-wheeler called them and wanted money for the damages. And my guy calls me and goes, you know, can I give him the video? I said, that's what it's there for. So we got an ROI after going a quarter of a mile that saved them how much on the totaled car who hit them in the first place. So, you know, I'd be interested in some type of scientific study in terms of how many absolve the trucking company or how many prove it otherwise. But, you know, again, like I said, I've had them from overweight tickets to leaving the scene of an accident where there's a witness there. And, you know, everybody from behavioral psychologist to Penn and Teller will tell you the worst evidence is an eyewitness. So, you know, it's the video that really presents it on that.
Rebecca, could I just go back to one thing, you know, Doug mentioned again about the voter guide and elections. What I forgot to mention in that is that we're limiting the voter guide for right now to the gubernatorial candidates because of the concentration of them in this primary election. For the general election, we will expand the voter guide to include the legislature. We do two things. We keep a running tabulation of votes in the General Assembly on civil justice issues, and we assign a session score and a lifetime score to each incumbent member. So that will be published. For open seats, we will be sending a questionnaire very similar to what we sent the gubernatorial candidates in open seats. And we will publish their responses in the open legislative seats, you know, for the fall as well. So I just wanted to point that out.
And in terms of trucking, Rebecca, we've got 1 out of 15 people in Pennsylvania who are employed in the trucking industry. I read your emails.
That's right.
And as in terms of a shameless plug, is there any financial way people can get involved in trucking and supporting the electoral process?
Well, sir, yeah, sure. I mean, I'm not a allowed
Truck
to
pack?
go into specific candidates or anything
Yeah.
like that, but absolutely, I would encourage everyone, if you determine there's a candidate out there that you like and is particularly responsive and understanding of the needs of the trucking industry, by all means contribute to them. I mean, it is no one likes to talk about campaign contribution, but it is part of the world that they live in, and they need the contributions in order to successfully get their message out to the public. So, I would certainly encourage that. And I imagine, Rebecca, I'm not sure if you folks have a PAC, but you might want to inform them of that.
We do. We have the Pennsylvania Truck Pack, and that is exactly the kind of information that we look out for in supporting candidates through our PAC. So information is available on our website for how to give to that PAC. And actually, Curt, you talked about the voter guide, which I always check out because obviously PCCJR can sort of go into more detail than each one of us individually can, look at through a Google search or whatever on particular candidates. So it's all there in one place. But the one area where I really appreciate your voter guide is in judicial candidates. Now, we don't have any judicial elections this year in Pennsylvania. This year is the gubernatorial and the
Right.
General Assembly elections. But we did have a big judicial election last year. Was last year, right?
Yes.
Where
Mhm.
Justice of the Supreme Court Kevin Brobson was elected,
Yes.
who is an excellent jurist for business interests and a lot of things we've been talking about here. And that's a good example of where a really solid backing for a judicial candidate really made a difference, I think.
We just had a
No,
question come in.
I agree.
We just had a question come in, Rebecca, about the efforts, and we've seen them in Congress over the last number of years, to raise the minimum insurance rates from 750 or million hazmat in comparison to the automobile, minimum limits of, I think in Pennsylvania, 15,000. And point well taken. You always run that dilemma. The more insurance you have, the more they're going to want. And what's even more damning about the breaching of the Fair Share Act is you're going to see more policy limits demands in minimal exposure cases on the theory of, hey, look, if you don't pony up, it'll go into the corporate level on that effect. So that's where that really comes in, and you work backwards. It goes from the threat to the corporation beyond the insurance limits to the Fair Share Act to the election of the courts, and it's an ongoing process.
Do we have any other questions from participants here? We're right on the nose at 1 o'clock. So anything else before we end our session today? Okay. Going. All right. Well, thank you so much, everyone, for joining us. We will have a recording of this available shortly. So if you want to come back and look at it, or if you feel like you missed anything or want to share it with your friends, it will be available. So we'll make sure we get that out and you know where to find it. So thank you, everyone. Have a wonderful rainy Thursday here.
Yes.
And we'll see you all soon.
Rebecca, it's
So
always
long.
sunny in Pennsylvania. So
There you go.
see ya. Take care, guys.
Thank you.
True. Thanks, guys.